Is that with a K?
Number 29, Your Honor. Klauck.
25 CR 5887, People versus Clout.
Kevin Warden for the people.
Good morning, Your Honor. Robert Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay, good morning.
And thank you, Your Honor. We've been working on disposition in this matter. Mr. Klauck informs me today that he would like to set the matter for motions and jury trial. So we would ask the matter be set for motions and jury trial.
All right, you want to enter a not guilty plea? Do you correct? And
at this time, Your Honor, I would like to relieve Mr. Robert Levine as my counsel, and I would like to enter a plea of not guilty, Your Honor.
are you asking to go pro se, or what are you asking for?
I am firing Robert Levine for violation of Title 18 United States Code 241 under conspiracy against one's rights. I have also some motions in my pocket in regards to complete dismissal of all charges, Your Honor.
Are you asking to proceed pro se? Are you asking the court to appoint alternate counsel? Let's start one at a time.
Alternate counsel, Your Honor.
Mr. Levine, are you ADC or are you private?
Your Honor, I am ADC and I work for Mr. Reich, who was appointed on the case as well.
Okay, so Mr. Reich is the appointed counsel.
Correct.
Right. Okay, and you're with his office. Okay, Mr. Klauck, in order for the court to appoint counsel other than the one that's already appointed, I have to make a finding that there's a legal or ethical conflict. Are you asserting a legal or ethical conflict?
Yes, ma'am, Your Honor, for violation of my constitutional rights of due process, and not only that, but also committing a conspiracy against me under Title 18 United States Code 241, Your Honor.
Okay, here's what I'm going to do because I have a pretty long big docket. I'm just going to pass your matter. We'll call your matter at the end of the docket, sir. You can provide whatever information you want, but I need to make that initial determination before I can proceed in either direction, and then you'll have some decisions to make. Okay, so we'll recall your case at the end of docket.
Yes, ma'am, Your Honor.
Okay.
All right, folks, today's case is a masterclass in self-inflicted legal disaster. We're heading to Colorado for a courtroom encounter where the defendant doesn't just misunderstand the law, he confidently weaponizes that misunderstanding against himself. This is one of those hearings where the judge is calm, the lawyers are professional, and the defendant, completely convinced he's uncovered a massive constitutional conspiracy, led by his own defense. You'll hear phrases, even a federal conspiracy statute, thrown around like magic spells, none of them used correctly. What makes this fascinating isn't just the legal ignorance, it's the escalation. He tries to fire appointed counsel, demands a new lawyer, flirts with going pro se, then backpedals, all while the court patiently explains the same rules he refuses to absorb. The twist: the judge gives him every opportunity to clarify, correct, and recover, and he still manages to dig deeper. So watch closely, this isn't just a bad argument. This is how defendants slowly sabotage their own cases in
Not my turn.
This is our motion to adjourn.
Mr. Klauck, we're going to call your case and then we can have a conversation, okay? This is 8 on the docket, 25 CR 5887, People versus Anthony Klauck.
Kevin Warden for the people.
Rob Levine on behalf of Mr. Klauck, who appears to my right in custody.
Okay. Good morning, Mr. Klauck. First, I wanted to say I told you on Monday that we'd hear you that afternoon. I was unable to do so because counsel were not available. So that's why we had to reset you for today. Any questions on that?
No, ma'am.
Okay. On Monday, I had set the matter over because, as I understood from Mr. Klauck, he wanted alternate counsel appointed. I indicated that I need to hear some more information on that. And then since that time, there's a pending motion filed by counsel indicating that they are requesting to withdraw. Is that accurate?
Yes, Your Honor.
Okay. The motion indicates that the basis for the withdrawal is that Mr. Clark wanted to proceed pro se, which is not what I understood on Monday. Is
That-
something changed?
Your Honor, that's based on my meeting with Mr. Klauk yesterday. That's the representation he made to me.
Okay. Mr. Clark, let me ask you, again, that's not what I understood you to be saying on Monday. Are you asking to proceed pro se, or are you asking the court appoint another attorney to represent you?
I would like the court to appoint another attorney based upon my Miranda rights, Your Honor, due to Mr. Robert Levine violating Title 18 United States Code 241, conspiracy against one's rights, and violation of due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution as well, Your Honor.
Okay. So a couple things there. I'm just going to advise you generally. You have court-appointed counsel. You are entitled to court-appointed counsel when you are determined to be indigent and you're in custody, so you're determined to be indigent. The court appoints counsel. In your circumstance, there was a conflict with the public defender's office that was determined earlier on. Based on that conflict, you were appointed, I believe, technically it was the law office of Scott Reich was appointed, but Mr. Levine has been representing you. Is that correct?
Yes, ma'am, Your Honor.
Okay. In order for the court to find a similar conflict or another conflict that would warrant appointment of yet another counsel, I can only do that if I find that there is a legal or ethical conflict.
Right here is where tone and credibility start forming, and that matters more than people realize. Courtrooms are not just about law, they're about presentation. Judges take note of how defendants respond to basic questions, how they identify themselves, and whether they're grounded in reality or already drifting into grievance mode. Nothing dramatic has happened yet, but listen carefully. The court is orderly, the prosecution is ready, defense counsel is present, and the judge is running a tight docket. This is a system functioning exactly as designed. Which is important, because when accusations start flying later, remember this moment. Nothing about this setup suggests chaos, bias, or conspiracy. His contrast is key. When a defendant later claims constitutional violations, courts look back at early interactions like this to gauge whether the complaint reflects reality, or a fundamental misunderstanding.
I advise you ahead of time that any conflict allegations that you make, to the extent that they may touch on privileged information between you and your counsel, that privilege would be waived as it relates to the conflicts that you assert. Same with confidentiality, it would be waived as to any conflicts you assert. Your attorney would be able, and indeed I would require that they respond to any allegations. Do you understand that you're waiving any privilege or confidentiality?
Yes, ma'am, Your Honor.
Okay. Help me understand, what is you mentioned the conflict has to do with Miranda. What is that?
In regards to Miranda, I actually have written motions that I would like to submit to the court and also the people as well, Your Honor. Is that possible?
I can't do it directly. You'd have to file it with the clerk so you can mail it.
Well, once again, Your Honor, I am in custody and I cannot file it with a clerk, and all I can do is written motions, Your Honor.
Yes, written motions are often filed by people in custody. You can do that through the jail in the mail. But if you'd like to make a record, and if that is in just reading from the motion, I'm happy to hear.
Yes, ma'am. I'd like to read the motion if that's possible, Your Honor. Motion to dismiss date 12/19/2025, defendant Anthony D. Klauk, who is present, Your Honor. Motion to dismiss charges in the Denver District Court Case 25095887. And the discovery, it can be seen.
Sorry, Mr. Clark, I'm going to stop you there. I'm not hearing a motion to dismiss charges. If you have motions relating to the conflict with your counsel.
And in regards to my counsel, Your Honor, I told him about the mistreatment I was going through in the county jail, and he still proceeded to want me to remain in custody. He still proceeded to try to cover up the fact that my rights were being violated in the county jail, Your Honor. and I gave him plenty of documentation, and even have a grievance form that I even submitted to the county jail of the jail, violating the False Records Act, and False Claims Act as well, with multiple officers violating their oath of office that they signed with the affidavit to the state of Colorado in regards to their oath of office to the United States Constitution, Colorado Constitution, uphold and enforce the laws of the state of Colorado.
Here's the moment the train jumps the tracks. This is not how firing a lawyer works, especially not appointed counsel. When the court appoints an attorney, that lawyer doesn't serve at the defendant's personal preference, they serve at the court's direction. You don't get to dismiss them because you don't like their strategy or because you watched a few constitutional videos online. That what's especially telling is the statute he cites, Title 18, Section 241. That's a federal criminal law aimed at prosecuting government actors who conspire to violate civil rights. It has absolutely nothing to do with a defense attorney representing a client in state court. None. Zero. This is the first major red flag for the judge. The defendant isn't making a legal argument, he's reciting legal-sounding language without understanding it.
It's regards to all the officers involved. I was never read my Miranda rights, Your Honor. And this is also found in the discovery as well, which means every officer involved in my arrest violated due process under the Fifth Amendment of the United States Constitution and Article 2, Section 25 of the Colorado Constitution. And also, with that being said, Your Honor, Title 18, United States Code 1918 is being violated by the oath of officers who are testifying against me or going to testify against me in the upcoming trial, Your Honor. And based upon my knowledge under Title 18, United States Code 1918, even the prosecutors themselves can confirm that that is a felony. And not only that, but also violating Title 18, United States Code 241, conspiracy against my rights, and Title 18, United States Code 242, deprivation of rights under the color of law, which is also felonies, Your Honor. And with Mr. Robert Levine violating due process and also committing felonies of conspiracy against my rights after he was informed, Your Honor, once again, confidentiality has been waived, as we agreed. And I did speak to my attorney about my rights being violated in the Denver Detention Center, downtown Denver Detention Center. And this seems to have not been reported to any.
With respect to that. Or I'm sorry, that Mr. Levine is doing or not doing.
Not informing the district attorney, prosecutor of the matters in regards to crimes being committed against me and me being discriminated in the Denver downtown detention center of my First Amendment under protection under religion, the Colorado Constitution, Article 2, Section 4, freedom of my religion, also violating the Civil Rights Act of 1967, Your Honor, discriminated against me under religion. Also, the state law of the Colorado Anti-Discrimination Act of 2013, also discrimination under religion, and not to mention violation of the federal law of the Religious Freedom Restoration Act of 1993. And I would like the court to know that as a Messianic Jew, I am kosher and do both Old and New Testament and the Holy Bible. And with that being said, I am also protected under the Anti-Semitism Act of 2023, Your Honor.
Is there anything further?
Other than that, my attorney clearly seen in the discovery that violation of due process, in addition to him being aware of my rights being violated in jail, also in the discovery that was submitted, the perjury was done, and the persecution of the state of Colorado still wants to proceed in this matter, which means they would be violating due process as well, which means they would be violating their oath of office to the United States Constitution based upon Matthew, who is one of the names in the mandatory protection order in my case in the discovery, committed perjury and with two different names of Cecilia and Sabrina submitting false evidence through Sarah Michaels at University Health, committing perjury and also violating the federal law of the False Claims Act. And the matter that he still wants to pursue the case and not defend me and bring this to the prosecution's attention, this in itself makes me feel like this is a conflict of interest.
I think what he is actually referring to is the SBI forms in the case. That's something we discussed. The SBI forms contain different names than the alleged victims in the case, possibly an oversight from Denver Health. I've explained to Mr. Klauk that having the wrong names on the SBI form doesn't necessarily mean that they can't prove the second degree assault allegations. That would probably be something that would be fixed pretrial with endorsement of the medical professional. I've met with Mr. Klauk 4 times during the pendency of the case. I'm realize that he has interest in getting out of custody and expediting this matter, and I've tried to take that seriously and step my foot on the gas for Mr. Klauk here in negotiating the case.
Quiet judicial control at work. Instead of immediately shutting him down, the judge pauses the case and moves it to the end of the docket. That's not avoidance, that's due process in action. She's giving him time to organize his thoughts, clarify his request, and potentially present something coherent. This matters because appellate courts look at moments like this. They ask, was the defendant heard? Was he given opportunity? And right here, the answer is yes. The judge isn't dismissing his concerns out of hand, she's saying, bring me something. Ironically, the more patient the court is, the weaker his later claims become. Because